I'd like to recall that there are two major roles in patent system. One is giving the incentives to R&D and commercialization. And the second important role is diffusion of technical knowledge. Our research is directed to the second role. More specifically, our research purpose is to investigate the effects of pre-grant publication system on the diffusion of technological knowledge. In order to investigate the effect of pre-grant publication system, we focus on the legal change in the United States. The American Inventors Protection Act, AIPA, was enacted in 1999. The AIPA introduced 18-month pre-grant publication system in the United States. Pending applications filed on and after November 29, 2000 are published after 18 months of filing date. But there is one exception. Purely domestic applications, the term purely domestic applications means patent applications that are filed only to the United States and are not filed to foreign countries. So it means there is no patent families. Purely domestic applications can choose secrecy before grant. But a recent study made by the Cheha Professor Graham revealed that more than 80% chose a pre-grant publication system rather than secrecy. So there expect to be a substantial effect of pre-grant publication system. Before AIPA, the publication date is same as the grant or issue date of the patent. So publication lag means the difference between filing date and the first publication date is same as the grant lag. After AIPA, pre-grant publication is made after 18 months of filing date. So the publication lag is reduced, and we expect that the diffusion initiates earlier because of the introduction of pre-grant publication system. This is the data divided technologies into 6 fields, roughly divided to 6 fields: chemical, computer and communications, drug and medical, electronical and electronic, mechanical, and others. This is a 1-year period before AIPA. 49 months is a mean grant lag. After the AIPA, the mean grant lag increased slightly to about 51 months. But the publication lag is reduced to about 29 months. So the difference between these publication lag is more than 20 months. In other fields, the reduction is of several months. In our study, we concentrate on the purely domestic applications because if there were patent families, the knowledge diffusion might occur to the pre-grant publication made by foreign patent offices. So that's why we concentrate on the domestic applications. And if we consider the long-term effect of the knowledge flow, there are 2 candidates. One is the facilitation of more complementary inventions. In this case, the number of patents that cites the focal patent increases in this case. But there are another effect, a reduction of duplicated inventions. In this case, the number of patents that cite the focal patent decreases. So the number of patents that cite the focal patent will increase or decrease depending on the relative importance of the 2 effects. So the hypothesis of our study is these. The introduction of pre-grant publication system accelerated the initiation of knowledge diffusion, especially in technological fields where the grant lag was long, computer and communication fields. And hypothesis 2, the effects of pre-grant publication on the shape of the diffusion curve could be heterogeneous, depending on the relative importance of the 2 citation flows, those for duplicate inventions and those for complementary inventions. These are major prior literature. And because time is short, I skip to this one. So Johnson and Popp's research is mostly related to our study, but the conclusion is similar to our study, but there was a fundamental problem in the data they used. Their data includes citation data, but their citation data includes applicant citation data and examiner citation data also. This figure in this figure, the x-axis is a citation lag. Citation lag means the difference of filing date between citing patent and cited patent documents. So the y-axis is the probability of citations. So in the applicant citation data, the probability reaches maximum value around 30 to 40 months. But in the examiner data, the citation jumps quickly. So it's inevitable to use only applicant citation data, inventor citation data to measure the citation flow. So the basic method of this study is to use applicant citation data to measure the diffusion knowledge. And we examine the change in inventor citation data before and after the legal system change in the United States. We also eliminate the self-citation data using by NBR Patent Data Project. The probability of citation is calculated by this formula, and where NIT means the number of the in here, N means the number of the cited patent document cohorts, where I mean the technological field, which is 1 to 6, and T is the filing date measured by calendar month. And M is M stands for the number of potentially citing patents. So the product of N and M means the potential number of potential citing pairs. And the C stands for the realized citation pair, the number of the realized citation pair. So C divided by the product of this means P, means the probability of citation. This is the model we used. We assume that probability of citation is proportional to the product of diffusion factor and obsolescence factor. Here, in diffusion factor, we used logistic function. We tried several functions, but only logistic function worked well. So this is the function of logistic function. If the tau stands for the inflection point, if tau became smaller, it means the diffusion occurs earlier. And we assume obsolescence occurs because there are many publications in that field. To measure the effect of the legal change, we used a dummy variable, rev, which is set to 0 before AIPA and which is set to 1 after AIPA. We tried 3 models, but I only explain model 1, which is the most general model. This model allows 3 parameters to change. So if the tau2 is negative and statistically significant, this means that knowledge diffusion occurs earlier. And the long-term effect is measured by alpha 2. If the alpha 2 is negative, reduction of duplication is dominant. And if alpha 2 is positive, more application, more patents, or more invention of complementary inventions is dominant. This is the actual data we measured. You can see that the slope became steeper after AIPA. This is before AIPA and after AIPA. The red points is fitted values. You can see that the fitting works well, I think. And this is the values, estimation values. In computer and communications field, the tau2 is negative and 16 months and statistically significant in the level of 1%. So it means that in computer and communication fields, knowledge diffusion began 16 months earlier after the introduction of AIPA. And there are also values which is statistically significant in the E&E field. The value is 3 months and negative, and 6 months in drugs and medical, and 3 months in mechanical, and 5 months in others. But in chemical field, this is marginally effective. And the alpha 2 is negative in the computer and communication field. This means the reduction of the application is dominant. In contrast, in E&E field, this alpha 2 is positive, so more inventions means. So let me conclude shortly. Except in the chemical field, there is highly significant evidence for the effect of pregrant publication on the acceleration of knowledge diffusion. And there might be a possibility that reduction of duplication is detected in the computer and communication field. Thank you very much for paying attention.
My name is Sadao Nagaoka, and I belong to the Tokyo Keizai University, and this work on the effects of stronger disclosure rule on applicants' behavior in Japan is jointly done by Maeda and Naito of Hitotsubashi University. In September 2002, the prior disclosure rule by the applicants was significantly strengthened in Japan. The objective was to improve the examination efficiency based upon the applicant's disclosure, and also to strengthen the stability of the patent right, basically improving the quality of the patent literature disclosed. Before the reform, prior disclosure by an applicant was not an obligation. It was only a recommended action. The objective of my research is to first, basically threefold: who discloses prior literature, and secondly, how such behaviors have changed in response to the legal change, and thirdly, the effects on the examination outcomes, including the speed of the examination, as well as the grant rate. It's important to note that claim construction by the applicants will become more aligned with prior art following their stronger disclosures. There are very few prior works, but for the sake of the time, I would like to just point out that the existing studies have not analyzed the issues which I'm going to present. So let me just start with the first point, the changes of disclosure behaviors after the legal change in Japan. This figure 1 shows the compositions of applications by the size of inventor citations. So the legal change took place in 2002. So if we compare the 2001 and 2003, about 60% of Japanese patent applications had no reference. So only 40% of the patent applications had 1 or 2 or 3 more references. But that changed significantly, and in 2003, the applications with no citations dropped only to 20%. So there were significant impacts on the disclosure behaviors by the Japanese applications. So we would like to have a measure of the disclosure quality. And we decided to use examiner citations, because basically, ultimately, examiner have to develop the full report of the prior art. So we can use the examiner citations as a measure of the disclosure of applicants. So this is applicant citations, and this is examiner citations, and this is common citations. So if applicant citations fully anticipate examiner citations, then that is a very good applicant citations. And actually, we have two measures. One is that how much out of the applicant citations are relevant to the examinations, B over A plus B. And another is that how much of the examiner citation is anticipated by the applicants. Basically, this is the denominator, and this is the nominator. So we use these two measures. And from that perspective, this shows the development of the evolution of inventor citations and examiner citations. So basically, inventor citation jumped after the reform in 2002, and there is a slow increase of the examiner citations over time. So this is a common citation. So common citations relative to inventor citation is relatively small, about 5% before the reform, but it increased to about 10% after the reform. This figure shows the disclosure quality in terms of examiner citations before and after the reform by sectors. So if you take a look at pharmaceutical sector, about 12% of the examiner citation was anticipated by applicants before the reform, but after the reform, about 30% of the examiner citation became anticipated by the applicants. So there was significant increase of the disclosure quality due to the reform. So the next issue is that who actually discloses. And basically disclosure and endogenous decision, and it is clearly depends upon the invention quality. That is, a firm gains from the disclosure prior art by an prior art, because it can get the earlier patent grant, or it can get a stable patent right. So basically, applicant with a good high quality invention can get more from the disclosure. But on the other hand, when the invention is of low quality, the disclosure can endanger the possibility of getting a grant, considering the possibility of the oversight by the examiner. So basically, this shows the basic trade-off, and basically, the theory suggests that the applicant will prefer disclosure when his invention quality is high. So, so the first issue is whether we can confirm this prediction based on the Japanese data, and so we ran a very simple regression explaining the disclosures based upon the invention qualities, and we use three measures of invention quality: the inventor team size, the number of claims, and the relative number of forward citations of the focal invention. And basically, as this shows the number of disclosures, and these two shows the quality of disclosures based on examiner citations and based on inventor citations. And basically, both quantity and quality improves with the three measures of the invention. So basically, higher quality applicant with higher quality invention prefer to disclose. So let me go to the effects of disclosure on examination. And for this purpose, we ran two regression models. One is on examination length with a dependent variable. Another is a grant as a dependent variable. And explanatory variables are both invention quality indicators, but as well as the disclosure variables. that is the size and quality of the disclosure, but the quality of disclosure defined in terms of structure of inventor citations. This gives the results of the estimations for the estimation for the examination length to the grant, and explanatory variables are the invention quality, 3 invention quality variables, and 2 disclosure variables. So if we compare, and this has fixed effect, first inventor fixed effects, as well as we control for the technology by application year dummies. And let me just compare the estimation results before the reform and after the reform. So basically, only after the reform, the quality of disclosure has negatively increase of the quality resulted in the reduction of the examination length. So basically, in the maximum, about 1 month. So if your disclosure is, all of your disclosure are relevant for the examination, the applicant can expect 1 month's reduction of the examination length to the grant. So there's a very substantive, there's a not very large, but still very substantive effect of the disclosure. This table shows the results of the estimation with the grant probability as a dependent variable. And if we compare, again, the estimation results for the pre-reform period and post-reform period, basically the applicant which disclosed more can get a significantly higher grant rate, that is 23% before the reform and 28% after the reform. So basically, inventor with a good disclosure tends to have a claim construction which fully reflects the prior art. So therefore, to the maximum, they can get more than 20% increase of the grant rate. And this does not fully control the endogeneity, although we use fixed effects, and we are under the process of doing instrumental variable estimation. And this is a Boston example. And the negative effect on the examination length and the positive effect for the grant rate we got, but at this stage, not significant under the instrumental variable estimation. So let me just go to the summarize my conclusions. So applicant or inventor discloses prior art more for a high quality invention consistent with theoretical prediction. The legal change in Japan in 2002 significantly expanded both the amount of disclosure as well as its quality in terms of examiner citations. Thirdly, the inventors who increased the quality of the disclosure in terms of inventor citations experienced the reduction of the length of the examination to the grant, maximum 1 month, and especially after, but only after the policy change. Those inventors also experienced the increase of the grant rate of about 20%. So thank you very much for listening to my presentation.
What I'm trying to do here is something very, very simple, or what the team is trying to do. We're trying to nail down a number. How many hours of time used up in making an invention does an inventor save by looking at prior art, at disclosed documents, right? And the reason for that is because some people have said, and courts have said, that that is very, very important, okay? There are whole stories around that. And I'll try to convince you that it's actually very, very small. So if we have disclosure effects, they might be more in the realm of what Sadao has described and so forth, but they're not necessarily in time savings, efficiency increases, and so forth for subsequent inventors. Okay, how do we go at that? Let's not waste time on the agenda. There are quite a number of economic rationales for patent systems, of course, right? There's the incentive effect. That's the story, the motivation, the argument that we bring the most often. Then there is disclosure effects. This is what I'll be talking about, and I'll refer back to quite a bit of the legal literature in the United States and also to US Supreme Court rulings who have very much emphasized this particular effect. There are, of course, many, many other objectives that the patent system might show. For example, safeguarding transactions. Merges has a nice paper on that. Signaling to inventors, right? More VC, earlier VC if you have patents, and there are some papers in that realm. And then, of course, there is the wonderful 2x2 matrix that Bronwyn has created, which shows that, well, if patents facilitate entry, for example, by facilitating access to venture capital, or by making division of labor more likely and so forth, or safeguard that particular division of labor in vertical value chains, then there is another pro-competitive, pro-innovation effect that they might have. And ideally would like to put welfare figures to all of these motivations in order to see which one is most important. I'm saying that given that last week, Thursday, I had a wonderful debate at the European Economic Association in a panel with Michele Boldrin, who's calling for the abolition of the patent system, and I was calling more for a repair job. But in order to repair, you would want to know with what objective in mind you would want to repair. Okay? Should we do something about disclosure or not? That's the question here. Okay, patent disclosure is seen by many scholars as something that is very important. If you read texts by Maklab, he argues, for example, that patent serves to disseminate technological information, and this accelerates the growth of productivity in the economy. I would like to know how big this effect is. I will focus on a partial effect of that. There are other arguments, twin purposes, encouraging new inventions, adding knowledge to the public domain. Legal literature is full of this. And of course, as you all know, full disclosure also has a meaning. For example, in opposition cases at the European Patent Office, claiming as the opponent that there wasn't full disclosure can be a very successful path towards getting the patent revoked, if you can show that in the opposition proceedings. US scholars, legal scholars, are very skeptical about the effect. Papers by Roy, Fromer, Seymour, and so forth. And the logic that they bring up is, look, disclosure would be very important for inventions that are hard to reverse engineer. Those that you can easily reverse engineer, why would you need disclosure in the patent document? You can just take the product apart, right? But the ones for which that are hard to reverse engineer are also the ones that are often protected by secrecy. Okay, so there's a contradiction, internal contradiction there. Then there's the argument that patents are explicitly written to be hard to read, to be opaque, because there are incentives not to show and tell. Okay? By the way, those incentives are there in science as well. We know very, very good evidence from science sociologists who tell us that the physicists, the chemists, and whoever, they don't fully disclose the experimental setup because there's a competitive advantage in having a little bit more information there. And something similar is going on here. And there's the argument that there might be legal risks, especially in the United States, willful infringement. If you can show that inventors were aware of something that later on is shown to be infringed upon, that could be turned into a willful infringement claim. Economists have done quite a bit, and this slide does not show yet the other presentations that you have heard today. But what we lack is really evidence, empirical evidence, as to what's going on. I'm trying to provide a little bit. This is not the complete answer, let me emphasize that. But I'm trying to attach real numbers and not to be very abstract. So it's very important. Empirical evidence is thin. Many legal arguments are based on this. There is an intensive debate in courts. So it's the optimal setting for bringing numbers in, and we do that by survey. 5 minutes, yes. How to operationalize this, how to measure this? We work on the assumption that patent literature contains technically relevant information and that reading patents allows inventors to apply that information to subsequent inventions, and we will ask them about time savings. Okay? And ideally it should be more than 5 minutes, which I have left. So how do we do that? This is the survey form. We first ask them which sources of information they use. That's a classical survey question. It's in the Yale survey. It's in many other surveys. Okay, and you have patent documents, scientific publications, unpublished technical documents, exhibitions, trade fairs. I don't want to go into all of them. If you compare Japanese, US, and European inventors, you see, first of all, that there are similarities. Okay, this is a spider graph. You see that communication with colleagues is a very important source of information. Patent documents, but differentially so, much more in Japan than in the US, than in Europe. Scientific publications following, and then there are other sources as well, which I will not go into. Okay, that's the response that we get from the survey. This is about 11,000 inventors reporting on particular inventions which we identified via an EP filing. So, step 2. Whenever they said that they read patent documents at least a little bit, we ask them this question. We would like to understand what the time saving was. And we give them this particular menu options where they can tell us in intervals what the time saving was, or they can tell us don't know exactly but definitely more, or don't know exactly but definitely fewer than XYZ hours. And out of that I will construct, by way of some statistical methodology, out of the interval data, I'll construct the distribution of time savings. Okay, here are some results that let me go directly to this one here, which essentially shows that in Europe, okay, patents are used less frequently than in the US, than in Japan. And Japan is ahead quite a bit on this. This is the distribution, which we turn then into the empirical distribution, which we then turn into order statistics. And I will show you the order statistics in just a second. So what we do is we do an order probit estimate. There's a lot of econometric shebang going into that. But essentially what we construct or reconstruct are the order statistics of the distributions. And here we are. This is a 10% percentile. That's the median. That's the mean. That's the 90% percentile. Okay. So 90% of all patents are below that. And this is the total number of observations for these technologies. So what you see here is that at the mean, in total, we have 11.5 hours of time savings per patent filing. But it's very, very heterogeneous across technologies, with electrical engineering really being at the low end, with chemistry being at the high end, which may, of course, have many, many reasons why that is, but I'm just reporting the statistics right now. Okay. This is the statistic after taking into account cases where patents were not used as sources of information at all, and we count them with 0 hours time saving. Okay? What you see here is that if you look at it by technological areas, you have relatively low median values on the order of 2 hours, 1.16 to 2.9 hours at the median of the electrotechnical areas, by a factor of 10 or 15 higher in chemicals and in chemistry. So, you can do multivariate analysis, and we do that. And of course, time savings in absolute hours increase with project size. That should be the case. There's a positive effect on the number of competitors who you are aware of, who are sort of working in the environment, going after something that is very similar. Okay? But even if you account for all of these effects, the Japan effect and the chemicals effect persists in the data. And by the way, if you do a back-of-the-envelope calculation, if you think that the hour saving is 10 hours, and you have, say, for Germany, 50,000 priority filings, okay? So then you end up with roughly 500,000 hours, and that's roughly equivalent to the spending of the Federal Research Ministry in 1 week. So I claim that that is a small effect. Conclusions. Time savings are relatively small with some heterogeneity across fields, and you see again how big the differences are with a factor of 15 roughly in between telecommunications and organic chemicals. I would say that the correlation between appropriation effects or incentive effects, I would claim that those are particularly high in chemicals and pharmaceuticals. That's sort of the credo of economists, that in these particular areas, patents have real incentive effects. And the disclosure effect is non-trivial, but it might be very fortuitous. Just imagine a debate of cutting back the scope of patent protection in certain areas. This is somewhere where you wouldn't necessarily want to do that, and you can take care of the disclosure effect and the incentive effect at the same time. The interesting fact here is that Japanese inventors, even in multivariate analysis, even after taking into account the number of competitors, realize for the same invention, for the same technology, higher time savings. That's a puzzle right now, which we need to pursue further. And it might have to do with engineering education and other things. There's very little evidence in favor of a positive disclosure story as adopted by some courts. We go to the second and the last page. Normatively speaking, can we get any evidence out of this whether it would be helpful to strengthen disclosure? My claim here would be not necessarily for the cost savings, maybe for other effects that are well worth studying and that Sadao has alluded to. So I'm a little bit skeptical about the Bessner-Mura argument and the Fromer argument. Now, you might say, time savings, isn't it? It's the spark of genius, the completely new idea, which has nothing to do with time savings and so forth, that generates the economic effects from disclosure. I'm open to that argument, okay? We should discuss that. My purpose and my objective here was to attach a number to a relatively limited, but in the literature deemed important effect, and to show that that is small. And that was it. Thank you.
So, with the setup we've already heard, and somewhat dovetailing on the comments that Dietmar and others have already made, there is this general view that patents provide relatively poor content to innovators. Biotech is a usual exception to this. But we have in the literature statements about the willfulness, particularly in the United States, the willfulness hammer in U.S. patent law deterring reading. And this is said to be a particularly acute problem in software. Ronald Mann suggested that software startups do not read patents. There's an article by Clemens in which I quote here, that patents are virtually useless for disclosure purposes. And in fact, there is no evidence of computer scientists or business method users searching patents for research. And Devlin, similarly, quoting, the IT industry in particular is infamous for producing patents that convey little, if any, information about the underlying nature of the discovery. Okay. So a question of this research project is to ask whether this view holds up in the face of evidence. There is evidence that has been generated here in Europe over the last few decades. The European Patent Office, in reporting on a survey that they had done, report that awareness of patents is greater among larger companies than smaller ones, that indeed small staff and lack of funds restricted the use of patent information by SMEs, but nevertheless, while the use of patent information by all firms was something in the arena of 21%, among applicants specifically to the EPO, it was 54%. So certainly there appears to be some information flowing. Arundel and Steinmüller reported that 12.5% of SMEs found patent disclosure to be important for their innovation, and it increases again to about 50% for larger manufacturing firms. Hall et al., not Bronwyn, as we discovered, but yet another Hall, and colleagues reported in 1999 that 43% of UK SMEs reported conducting patent searches. There's also similar evidence from the U.S., both from Ian Coburn, Rebecca Henderson, and also in the original Cohen, Nelson, and Walsh set of surveys. But because this is the EPIP and this is stuff coming out of the U.S., I'll save time. Okay. Let me get on to the data. So the data and the evidence that I'm going to present today comes out of the Berkeley Patent Survey that was conducted by colleagues at UC Berkeley in 2008. Pam Samuelson is here at the conference. One of my co-authors and co-participants in this project. We administered a survey to young U.S. technology firms in high technology, biotech, medical devices, IT hardware, and IT software and internet. We received over 1,300 responses from unique firms, generally from CEOs and chief technology officers. These were drawn from two different samples. We used Dun & Bradstreet, a credit reporting agency, to approximate the population of young firms in the economy, and also oversampled on venture-backed firms by using the Thomson's database. These were all young technology firms, no older than 10 years old. So our respondents reported on a wide range of firm-specific details and innovation-relevant attributes, including their innovation and business strategies, the means and the importance of different methods for effectively competing with their innovation, and the origin and reasons for patenting, et cetera. Okay. So this is the critical question that I'm going to be pointing us to over the next 5 minutes. And one of our questions asked respondents to report on their use of the patent literature. So does your company regularly check the patent literature to determine if someone else has a U.S. patent that covers what you're doing or what you're considering doing? Right? And for those that answered yes to this question, we asked them, at what stage does your company usually conduct such a patent search? And then we asked them to check all that apply here. I'm going to be focusing in on the top three, which are associated with the temporal dimension of the innovation process. Prior to product process design, during product process design and development, or during and after product and process launch. So what do we find here? This is this reports to you graphically the share of companies. These are all U.S. young technology companies. This is also broken out for you by the technology sector they're operating in. And what do we see here? So VX is the venture-backed firms. They come from the venture expert, so that's the oversample. Dun & Bradstreet would be the population of firms. What you immediately will notice here is that the venture-backed firms in all technology categories are more likely to tell us that they are checking the patent literature. And again, it's do you usually check the patent literature? So they are usually checking it. Nevertheless, even among the population of firms, you can see certainly sectoral differences, with software firms telling us that they are less likely to check the literature. But nevertheless, in every category, there is a substantial share of firms that are telling us that they are regularly checking the literature. Okay. Of course, among those that actually did check the literature, we asked them this second question. And what I report here is on the Dun & Bradstreet population firm sample. And you can see that across all these categories, those that said they were reading the literature told us that when they did it, that generally they did it at a relatively early stage in the process, either prior to or during conceptualization. Right, and much less likely after product launch. Okay. So tends to be early. Now, a question that arises is this effect driven by patent owners only, those holding patents? And so what I was able to do here, again, among the Dun & Bradstreet population of firms sample, was to split this out between owners of patents and non-owners. And what you see is, probably not surprisingly, that owners are much more likely to tell us that they are reading the literature, right? But nevertheless, even among those that aren't holding patents, and it turns out that in biotechnology and medical devices, this is a relatively small share of the firms, and nevertheless, you can see them in the software space, a relatively large share of the firms are not holding patents. For everything we know about patents and competitive advantage in this space. Nevertheless, it's certainly not the case that the patents are going unread in that sector, even among those that aren't holding patents. Okay. So I actually broke this out into software and internet only, and you can see here that among those that are owning and not, that we can see here that indeed in the venture expert side of things, right? If you're owning and not owning this is the venture-backed firms, right? The results are quite similar. Okay. So I'm going to report to you now some regression analysis. Sadao, how many minutes do I have? About two? Two. Excellent. Perfect. So I'm going to present to you some regression analysis. I'm going to dig in here so you don't have to like strain your eyes to see this this rather washed out chart. Note that I'm going to be reporting the results of logit regressions here with random effects. Okay, so the top of that panel to show you what's going on here. The baseline category and sector is a comparison against those firms that are in biotech. So you can clearly see that the significant value here is in software, with software firms being less likely compared against the others to be reading the literature. Interestingly, for these firm-associated characteristics, if the firm is VC-backed, we get a weak but positive association with reading. And this is quite interesting, and a much stronger effect here, is if a founder of the firm had prior experience running a startup company, this is positively associated with reading the patent literature. You also see this effect controlling for revenues and age, in which the number of employees in the firm, as the firm gets larger in terms of its employees, it tends to do less reading. Okay. The implications of that, of course, are hard to tease out, right? Is this a substitute for having enough personnel, engineering personnel on board? It's not clear. Also, I'm able to report here in terms of when a firm owns patents, as we saw before in the simple descriptives, indeed in the multivariate it holds up that you're much more likely to read the literature if you're owning patents. But I was also able to break out what this ownership means, right? So we had asked questions about, are your patents coming from founders? Are they purchased in? Or are you filing them yourself? And indeed, this effect is associated with the filing them yourself. Okay. Lastly, a couple of areas I was able to dig in on. We had also asked questions about how important various types of innovation are to the firm. And interestingly, the place in which we see reading popping out is when firms told us that process technology was important for the long-term business strategy of the firm. And lastly, I break out how important these firms told us various intellectual property mechanisms were in in protecting their innovation generally. And interestingly, reading is more common, at least in the multivariate, when folks tell us that certainly patents are important, but also when secrecy is important to them, and much more weakly when trademarks are important. Okay. I'm not going to report on this and just get to my conclusion, other than to say that when we run this regression exclusively using the software and internet companies, we get qualitatively the same results. Okay, so no big differences here. Some changes that are of interest, and I will certainly report in the working paper, but qualitatively the same. Okay, in summary. We have a general view the patent information is not used in the innovation process, and that's not consistent with our evidence. And this is particularly true in the software and internet space. This is regularly reported as having not good disclosure, and that the innovators in which are routinely ignoring the patent literature. So, of course, we find it much more common in the medical technologies, but not uncommon even in IT and software and internet. We test this out with a multivariate. Next steps, clearly. So, are there performance implications to reading? However we might define performance, innovative performance, performance in other areas. Importantly, particularly because of the way we ask this question, can we separate reading patents from reading information? If I could take just a small segue to say that indeed, this question was raised to me when I presented this once before by Mike Moyer, right? Asking me, why are they actually reading this? Is it actually to get the information in the innovation process out of the patents, or is it reading for strategic purposes that these firms have? I think that's a very interesting question. I'm not sure I'm going to be able to definitively get at that. But at the end of the day, one thing is clear, that when these folks tell us that they are reading, and usually reading the patent literature, it must be that the patents are conveying some information to make that practice a viable practice for a young firm to do. So with that as closure, it's an opportunity now to maybe for Dietmar and I to talk a little bit about how one might get these two stories that we just told together. And I'll invite the panel up, and we'll entertain questions from the audience.
In my university and in all academic inventors read patent, all of them, but not when they invent. When we decide to innovate, because the patent attorney will always ask to read the state of the art of some patent they identified, and making sure scientifically that what they did is novel with respect to what was already patented. So all scientists, when we file a patent, must read, because they are the most able to understand whether they really innovate, have something novel, and so on. So I'd like to ask Dietmar, in your patent, you asked a question about invention process, and this I can understand. But at least they must read it for the freedom to operate, because patent is about freedom to operate. You want monopolistic power, you must secure freedom to operate. You need to assess the state of the art.
And I'll let you get to two, but let me just dovetail a little bit on that. And maybe Dietmar, I don't know if this is in the data, but...
I thought that's my question.
Yeah, no, wait. No, wait. I finish my questions and then you go ahead. Sadao, was the policy in Japan, very interesting results, but was it associated with a change in management of examiners? Because at the EPO they have productivity objectives. So did the government went with productivity objective? You changed the law, you ask them to be more productive, and so it would also explain why you identify positive impact. And a second question for you, Sadao. I wonder what the law looks like, because at the end of the day, the good citations fluctuates between 15 and 27% of the examiner citations. So what is the punishment? What's the incentive? I mean, it's not, they still disclose only maximum 20-25% of what is needed. So what is the incentive of inventor to look for I mean, to be good, are they punished or what?
Well, as I emphasized, I'm looking at one particular aspect that has played a role in the literature, and that's why I'm trying to nail down an actual economic number, which is hours saved, in order to get away from Likert scales that are somewhere between very important and not so quite important, which tell us very, very little about the economic effect unless we scale them in some way. And I think we need to get away, or at least complement these Likert scales with other things. So I'm buying that, more precision, at the expense of breadth. What you are pointing to is FTO. That's a coordination activity. Okay? So the folks at your university and in other companies, and by and large, not all of them, yeah? Not all of them do that, but a large share of them do that in order to then tailor the pattern in such a way that they have some exclusion right in a meaningful area. Okay? That's a different effect from my perspective.
Okay, thank you very much. Two questions. So first one is that why JPO chose that policy, and I think productivity is clearly answered, and because of the backlog problem at the time, the examiners wanted applicant to clearly identify the prior art, and that would help the examination process. That's very clear. And, but also I think that applicant disclosure has been found to be important, especially in those technology areas where prior art in the form of patent literature is scarce. Like for example, I mean, maybe not good example, but for example, business method patent. And also in those areas where science literature is very important. And so even if the percentage covered by applicant citations is relatively small, but they may still provide very important information for the examiners where they should look for the evidence. Yes, Alan has some comments.
Sir.
Okay, I'm not who you're pointing to, but I got the microphone. So, Stuart, I assume from what you pointed out, or what you gave us, you probably can't distinguish this yet, but I wonder if you've thought about how you might distinguish two different effects, right? So you showed us that, having patents cause people to read patents, having prior experience cause people to read patents, and so on. And there are two possibilities there. One is, I've seen patents in action, I know how important they are, so I want to get them for my company, right? As opposed to patents are freaking difficult to read, right? The first time somebody sees a patent, particularly an engineer, they say, this just looks like gibberish. And so having experience with patents actually allows me to extract information from it because I have experience knowing how to read this funny claim language and so on. I didn't see how you could separate those from your data, but I wonder if you thought about how you might separate them, because those are two different effects, and the latter one seems more plausible to me, but I don't know.
Yeah, I haven't thought of that, but that explanation is certainly consistent with many of the things here, right? The experience, those that are actually filing are reading, right? So all of these would tend to would be consistent with this story that you're spelling out. That and everything that we know, right? There are learning curves everywhere.
Exactly.
My question feeds into what Dan has said. So the patent, as we all know, is a quid pro quo between, on the one hand side, the private interest and the exclusionary right, but also the societal and public interest disclosure. So my concern would be, to what extent does the disclosure allow a person skilled in the art to rework the invention? Reading, for me, is not a measurement of the quality of the patent disclosure in enabling someone to rework the invention. So I'm wondering to what extent your research or additional research is looking into the quality of the patent description in order to allow others to rework the invention. And there, of course, software has been said to be problematic because from the information in the patent description, there's no algorithms, there's hardly anything which allows you to rework the invention.
It's certainly an important question. I'm not sure I'm going to be able to get at it with our data, but I do think that DMAR has something to say, and certainly I think probably Sadao has something to say too on this score.
I just wanted to emphasize in our multivariate results, one more year of experience as an inventor adds 0.01 to the time savings elasticity. So that's congruent with what you had said, Dan. The second point, Gertrude, I'm not interested in reworking the invention. Okay, that is of course a necessary step, maybe. Okay, and that's the legal perspective. I understand that, and that's valuable. As an economist, I'm interested in what can I do with that information that I get from reading the patent. Can I do something completely new? Can I do something more efficiently? Otherwise, I'm taking the stubborn economic view here. I'm not interested. I'm not buying. Yeah, but I wouldn't stop at reworking the invention. I want to know then what is the savings effect or the complementarity effect or whatever that I can have afterwards, or what is the positive value effect out of doing better coordination in a freedom to operate, which might be the different perspective. Yeah, I think it's an important step to be able to rework, but it doesn't stop there.
Of course, I'm not just interested in the concept of the quid pro quo. I'm interested in the fact that if I can rework it, I want to rework it because I want to improve it. And so I'm interested in the improvement aspect of it. But
no, I may not even want to improve it. I may just want to take the solution concept, use the knowledge that is somehow embedded, and do something productive with it, whatever it is, right? But you're right, that's the first step. But I'm trying to hop over that step and go directly to the economic effects out of that.
Yeah, well, I mean, one of the issues, and this goes to the question I was going to ask, dovetail on Bruno's on, was so. There's selection in your sample, Dietmar, in that they are inventions that were ultimately patented. I guess the question is, did you ask any questions about, in your overall scope of invention, right? Did you more quickly abandon projects because of what you've been reading? Now that might be baked into this whole process of how you get to a patentable invention. It may be, or it may not be. And one wonders if that sort of negative knowledge, right, that we can't observe, isn't in some way affected.
But again, that's the coordination, right? Do I abandon, do I change the path of my invention process and so forth? Those are valuable questions. I'm not doubting that. I'm not responding to that. I can tell you that complete abandonment or complete new start of projects is a relatively rare outcome of reading patents. It's adjustment that is important.
Can I ask a question about I'm a patent attorney. I write these funny documents. And inventors don't like reading them, but what the patent publication does is open up publication through other sources. How much of other sources is used? Now, in the work you carried out in Japan, were the citations given by the applicants primarily non-patent literature? Because one would expect that, perhaps, in some circumstances. The chemistry correlation, you can do, if you can do patent clearance, then you read patents. If you can't do patent clearance, then you don't bother. And if you don't need to do patent clearance, you don't bother to read patents. Again, that's something that correlates. So large companies that have got huge cross licenses don't bother to read patents because they haven't got to worry about freedom of action. In chemistry, with freedom of action easy to do, then you read patents because you can actually do the patent clearance. So is the fact that materials published in patents, does that matter? Is it the fact that you can publish elsewhere in manuals, in scientific publications, journals, on the internet? Is that really the important thing about 18-month patent publication?
Yeah. Yes, I think that. I think that it is important. I think that the many defense publication, even if for the purpose of defense publication, I think the patent application is very important. As seen from the inventors, and also I think that, as you say, that non-patent literature is also very important. But my research just focuses on patent literature.
So I've been given the hook. Thank you all very much.
Thank you.